I would like to first thank you for this unique opportunity to present on one of the topical issues related to rule of law and internationalization processes and international law in general. The topic of crimes against humanity committed during the Russian-Ukrainian War, with all of its legal and jurisdictional issues, aspects, as well as responsibility challenges, can understandably not be comprehensively covered over only 20 or 22 minutes. However, I will try to point towards its most relevant and key aspects pertaining to this type of international crimes in the context of the ongoing armed conflict in Ukraine, and if there are any questions on those afterwards, I will be happy to do my best to respond. Of course, I realize that some of those issues have already been well covered by my colleagues here, but I really hope that I will be able to bring some additional helpful reflections, ideas, and conclusions to those issues. Some key general legal as well as substantive issues first will have to be discussed, and I know that many of those issues will also be discussed and reviewed today and tomorrow by my colleagues in more depth. So crimes against humanity, along with genocide, war crimes, and the crime of aggression, as you all know, they constitute the so-called core crimes, or crimes under international law, as they are understood in contemporary international criminal law. They are mass crimes against civilian population. And of course, I'm talking about these legal issues because this is the concentration of my research. I specialize on those crimes, so I'm hoping that it will also provoke certain interesting questions afterwards as well, before I connect them to the context of Russian-Ukrainian War. The modern definition of crimes against humanity, as it was already mentioned previously during the presentation of our keynote speaker, Dr. Egan, thank you for that, it is firmly established in the Rome Statute of the International Criminal Court in its Article 7, where it includes, as you all know again, a range of individual acts that are committed as part of a widespread or systematic attack directed against any civilian population, with knowledge of the attack, such as murder, extermination, enslavement, deportation, or forcible transfer of the population, imprisonment, or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, and some other acts. Now, certain important aspects of crimes against humanity deserve a brief mention here. I know there will be a specific presentation on genocide, so this will be very brief in terms of a comparative perspective. There are some major differences between crimes against humanity and the crime of genocide. Why I'm talking about this is that later you will see that this also serves as some sort of one of the factors contributing to misunderstanding of what these crimes truly represent, including by Ukrainian legislators and law enforcement agencies and judges. So I feel the need to discuss it too, for the sake of clarity. Crimes against humanity have a broader scope than the crime of genocide, since they include individual acts which are not encompassed by the existing definition of genocide in accordance with the UN Convention Against Genocide and the Rome Statute's definition as well. In other words, the concept of crimes against humanity extends beyond genocide, includes acts committed against the perpetrator's own citizens, regardless of whether it occurs during wartime or peacetime, and that's also very important. The second difference consists in the international element of the crimes. For crimes against humanity, that element consists in the widespread or systematic attack against the civilian population, the so-called contextual element. While for genocide, the context of organized violence is linked to its mens rea. The violence comprises of the intended destruction of a protective group. Crimes against humanity do not have that particular mental element. Yet another main difference between the two crimes lies in the difference between their protected interests. And the question of protective scope of crimes is also quite often omitted in the available literature, in the discussions, including the discussions at the international and regional level. In the case of genocide attacks, aside from threatening peace and security of the world, it is the people's group's right to existence, individual interests and rights of the attack group members, as well as the victim's dignity. These values, these rights, represent the protected interest of the crime of genocide. In the case of crimes against humanity, attack, as you may recall, it is humanness, humanity as humanness, and its constituent element of freedom, human dignity, humaneness, civilized attitude and reason, as well as fundamental human rights. According to the meaning of Article 7, Paragraph 1 of the Rome Statute, crimes against humanity include only those crimes which are defined as committed as part of a widespread or systematic attack directed against any civilian population. And this contextual element represents a necessary requirement in order for a crime to be qualified as a crime against humanity. It is the so-called chapeau element of the crime. It is what makes the crime truly international by distinguishing it from domestic crimes such as murder, torture, rape, enslavement, and so on. Hence, it may be called an international element of the crime. The civilian population element is one of the key parts of those crimes' definition. As rightly noted by the late Professor Robert Cryer, the word "any" highlights the central innovation and raison d'être of crimes against humanity. That the law of crimes against humanity also covers crimes by a state against its own subjects and not only protects enemy nationals, and that's also very relevant, is an established interpretation of this element. The phrase civilian population encompasses any group of people linked by shared characteristics that in turn make it the target of an attack. The nationality or affiliation of the victims is irrelevant. Hence, crimes against humanity are directed against a civilian population as such, not merely as an individual. As an example, the occupancy of a certain territorial area can be cited. In turn, as concerns the requirement of widespread or systematic attack, and my Ukrainian colleagues also, they asked me multiple times in the past about the interpretation of this particular element, so I would like to bring it up here as well. Article 7, again, paragraph 1 of the Rome Statute, contains truly an explicit requirement, and it uses a disjunctive. To attack must be either widespread or systematic, not and. In other words, a prosecutor needs only to satisfy one or the other threshold. As for the element of attack, which is also quite often confusing, it is defined in the statute as a course of conduct involving the multiple commission of acts referred to in the paragraph 1, pursuant to or in a furtherance of a state or organizational policy. Here, if I may have the... Thank you very much. Okay. All right. Of a state or organizational policy. The term attack is not used in the same sense as in the war crimes law. It does not necessarily have to involve the use of armed force. And when they were deliberating several years ago in Ukraine, the amendments into the criminal code, that particular element, the word attack and its exact meaning, was truly confusing for the domestic prosecutors, the office of the prosecutor, as well as domestic judges in Ukraine. They were always connecting the context of crimes against humanity to the wartime context. So that's, I think that's very important. In other words, a military attack is not necessary, which is explicitly stated in the elements of crimes. The attack may include any mistreatment of civilian population. Now, after this broad overview of the substantive law of crimes against humanity and some of its key relevant aspects, I would like to draw attention to the picture on the title of this presentation. Can anybody tell me what is depicted here? Just very quickly. The famous photo. Exactly, this is Bucha. This is what happened in spring 2022 as a result of the military invasion of the Russian armed forces in the city of Bucha. You can see there the corpses, lying corpses of the Ukrainian nationals killed as a result of the barbaric acts committed by the Russian soldiers. Okay, I hope this will, yeah. I already, yes. Okay, I would like to mention also that here that in the discussion on including a disposition or corpus delicti of crimes against humanity into domestic law, and Dr. Bogusz also mentioned the lack of that disposition in the Ukrainian criminal legislation. They also have to pay attention to language issues, because in the Ukrainian language, and it's a very similar problem existing in the Russian legislation as well, the translation of the phrase crimes against humanity is, how to say, it's quite confusing also, because compared to English translation of the word humanity, in Ukraine, the phrase as it sounds in the Ukrainian language, «злочини против людяности», would be exactly translated as crimes against humanity in its meaning as crimes against humaneness, okay? As versus «злочини против людства», which would be exactly translated as crimes against humankind, which seems to be the preferred interpretation of this particular phrase, not only by the Ukrainian authorities, but the majority of the post-Soviet space criminal legal jurisdictions, as we know it right now. Not all of them, but the majority of them. Okay, so now coming to the main issue of this type of core crime committed during Russia's aggressive war against Ukraine, and I think that by now you have already figured out I'm going to be only focusing on the period after the 22nd of February 2022. In particular, during its ongoing phase after the invasion, I would like to first highlight one thing. It appears that most of the scholarly and analytical sources, they tend to report and deal with war crimes, another type of core crimes under international law. And indeed, this is rightly so. So much evidence points toward the actual commission of such crimes in this war. Of course, they have to be reported, they have to be talked about, they have to be prosecuted. However, this also means that the coverage on crimes against humanity is quite scarce. And now this is not rightly so. There have been multiple sources of information. It's all the more surprising that this is happening. And they are reliable sources of information, but also publicly available reports confirming the commission of various acts fitting the modern definition of Article 7. In other words, qualifying as crimes against humanity that occurred on the territory of, Ukraine. And against the civilians of Ukraine, entailing much suffering, destruction, and death. Let me first answer the question. If you ask me, have crimes against humanity been committed in Ukraine after February 2022, my answer is yes. And now let me explain why. Here are some probably most evident examples. This is not an exhaustive list of the acts which fall under the definition under Article 7. First of all, the murders in Bucha itself, which took place in April 2022, the acts of torture committed in the city of Irpin, Hostomel, Kakhovka in March and April 2022. I'm trying to be avoiding mentioning the exact figures because the available reports, they tend to use different figures. So, and in the context of war, it's very difficult to say with 100% confidence that the figure you're dealing with is absolutely the final one, right? However, there are some figures used as well in my presentation. Deportation or forcible transfer of population. There are numbers ranging from 300,000 to 500,000 Ukrainian civilians, but these are numbers for spring 2022 in March and April again. Undoubtedly, they have risen since that time. Forcible deportation of children to Russia, it was already mentioned before, to Russia and also to occupied territories. Possibly 6,000, but now I gather more than 10,000 since the start of the military invasion up to present. Deprivation of physical liberty, around 222 cases from March till end of May 2022. Rape and other sexual crimes, thousands of cases since start of the invasion. Deliberate starvation, the famous starvation cases in Mariupol and Kherson, as well as other areas. And there is more. The information used for these horrifying examples, this is available in numerous United Nations, the OSCE, as well as the reporting of the already mentioned Independent International Commission on Ukraine created in Norway, as well as Human Rights Watch reports. These are open and official sources. As the case usually is, all these acts represent at the same time serious violations of international human rights law, which also was mentioned before. Now, if you look at the way the actus reus of these acts have been committed, if you look at the consequences, if you look at the concrete outcomes of these horrendous acts, and if you look at the context in which these acts have been committed, for any international law scholar and jurist, becomes clear these are crimes against humanity. Of course, we can discuss the details. We can look at particular elements and details of these acts. However, the fact that they have been committed during wartime, and the fact that some of them, or many of them, could also qualify as war crimes, does not mean that their characterization under the legal regime of international criminal law does not constitute the commission of crimes against humanity. Okay. Now, it would be difficult to avoid the discussion also of jurisdictional issues, and it's going to be coming up again and again, as I'm sure, during also this the course of this conference. The first inevitable question, okay, that appears in the mind of any international lawyer or scholar would be the delivery of justice for the perpetrators of these crimes. There are jurisdictional issues that need to be tackled if the eventual aim of not letting the perpetrators to get away with impunity is to be upheld. There are two levels here that we can note. First of all, delivery of justice at the international level. As you may already know, even if the Russian Federation and the Republic of Ukraine, they are not officially state parties to the Rome Statute of the International Criminal Court, Ukraine has already submitted or lodged two formal declarations of acceptance of the ICC's jurisdiction. The first one was lodged back in 2014, allowing for the ICC to step in for the events which happened after, from or after March 2013, and later in 2016, if I'm not mistaken, the second declaration has been also lodged, allowing or enabling the ICC to conduct an investigation into the events which took place since November 2015. So that allowed or allows for the prosecutor's office of the ICC to conduct its investigation. And of course, we all remember the states group referral of the situation in Ukraine to the International Criminal Court, in itself a unique event which triggered the ongoing processes right now at the level of the ICC, at the international level, with respect to what's happening in Ukraine. Now, I share and sympathize with the frustration which has already been expressed today about how exactly these investigations are ongoing. Indeed, as we all know, the international criminal justice processes, they take a long time. They're cumbersome, they are costly, they can be depressing, they require lots of patience. And well, the hope is that this investigation will lead somewhere eventually. Right now, many people have been, including in Ukraine itself, asking where exactly they're moving to, what's the outcome, where are the warrants, and so on and so forth. Yes, so the hope is there. However, one may also ask, what about another mechanism of international criminal justice system, which would be the famous concept of universal jurisdiction? And as far as I know, it's not an alien concept for Belgium too. Okay, it's part of that system, as well as Germany and some other European states, as well as in some other regions of the world. This is a concept that right now has not been introduced in the jurisdictions of the post-Soviet space states. Can crimes against humanity be prosecuted using, in this war, using this particular mechanism? On the side of individual states, the answer is definitely yes. Has they triggered those processes? That's another question. And I cannot recall right now any examples of that concerning these particular acts that I described earlier in my presentation. Now, the second level of the jurisdictional issues would be the domestic level. Okay, some of you may know already that in modern international criminal law, the preferred approach for arguing in favor of efficiency of delivering international criminal justice would be to conduct trials at the domestic level. At the end of the day, having trials in the context itself bears its own positive advantages and pluses, being closer to the evidence, having mechanisms which might act in a faster way compared to international level, and so on and so forth. However, for that, you need to have particular conditions set and established in the domestic legislation. And that's a problem for Ukraine as well, because, as you now know, crimes against humanity's corpus delicti are not right now figuring in the criminal code or in the criminal law of Ukraine. And that's the case for most of the post-Soviet spaces. As an example, I can tell you about Central Asian region, where the only country, the only state which introduced these dispositions in their criminal code would be the Kyrgyz Republic so far. So, okay, basically, I wanted to talk more about this, but I'm being told that my time is, approaching fast. So, since this is the conference dedicated to the role of international organizations, I would like to mention 3 key points in that particular regard. Of course, they can do something. Of course, they can bring an added value to the ongoing processes, justice processes in the world as concerns crimes against humanity. First of all, international or humanitarian organizations, they can be very useful in terms of reporting the crimes, including crimes against humanity, and that might be additionally used by the prosecutors at both levels in order to work with evidence and use these reports for the purposes of obtaining credible evidence. Second, these organizations, the ones that I already named, and there are many more, including the civil society organizations, they can bring up these issues. They will have to discuss them so that the agenda in the world is not left without crimes against humanity at their focus. Okay? They can help bring these issues up so that the humankind remembers about this issue. And certainly the last point would be contribution to the development of relevant treaty law. We all now know, we have heard Professor Egan about the ongoing efforts in bringing to life the famous new Convention on Prevention of Crimes Against Humanity, and this is the initiative which is being pushed by the United Nations International Law Commission. So, for this particular reason, their efforts in conducting events, organizing conferences, bringing together states, in order to develop relevant treaties, relevant treaty instruments, including this one, can be very useful. This is it, although I wanted to have more, but unfortunately, I don't have time left. I would like to thank you very much for your patience and for your attention, and if there are any questions later, I'll be happy to deal with them. Thank you.